Okay, so let's move on to Rule 119, Trial. Section 1, Time to prepare for trial. So after a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial, and the trial shall commence within 30 days from the receipt of the pre-trial order. Section 2, Continuous trial until terminated. So trial, once commenced, shall continue from day to day as far as practicable until terminated. It may be postponed for a reasonable period of time for good cause. The court shall, after consultation with the prosecutor and the defense counsel, set the case for continuous trial on a weekly or on a short-term trial calendar at the earliest possible time so as to ensure a speedy trial. In no case shall the entire trial period exceed 180 days from the first day of trial, except as otherwise authorized by the Supreme Court. So the time limitations provided under this section and the preceding section shall not apply where special laws or circulars of the Supreme Court provide for a shorter period of trial. So exclusions. The following periods of delay shall be excluded in computing the time within which the trial must commence. Any period of delay resulting from other proceedings concerning the accused, including but not limited to the following: delay in delay resulting from an examination of physical and mental condition of the accused, delay resulting from the proceedings with respect to other criminal charges against the accused, those from extraordinary remedies against interlocutory orders, delay from pre-trial proceedings provided that delay does not exceed 30 days, orders of inhibition, finding the existence of prejudicial question, um, reasonably attributable to any period, not to exceed 30 days, during which any proceeding concerning the accused is actually under advisement, any period of delay resulting from absence or unavailability of an essential witness. So for purposes of this paragraph, an essential witness shall be considered absent when his whereabouts are unknown or his whereabouts cannot be determined by due diligence. He shall be considered unavailable whenever his whereabouts are known but his presence for trial cannot be obtained by due diligence. Also, any period of delay resulting from mental incompetence, physical inability, the information is dismissed upon motion of the prosecution, reasonable period of delay when the accused is joined for trial with the co-accused, any period of delay resulting from continuance granted or by any court motu proprio. Yan. So, lahat to sa Section 3 exclusions, hindi yan kasali sa pagbilang ng 180 days. So, pwedeng lumampas sa 180 kung present ang mga yan. Section 4, Factors for granting the continuance. The following factors, among others, shall be considered by court in determining whether to grant a continuance under Section 3F of this rule. And so whether or not the failure to grant the continuance in the proceeding would likely make a continuation of such proceeding impossible. Whether or not the case can be taken as a whole is so novel, unusual, and complex. In addition, no continuance under 3F of this rule shall be granted because of congestion of court's calendar or lack of diligent preparation or failure to obtain available witness on the part of the prosecutor. And time limit following an order for new trial. So if the accused is tried again pursuant to an order of new trial, the trial shall commence within 30 days from the notice of the order, provided that if the period becomes impractical due to unavailability of witnesses and other factors, the court may extend it but not to exceed 180 days from the notice of the said order for new trial. Extended time limit. So, notwithstanding the provisions of Section 1G Rule 116 and the preceding Section 1, for the first 12 calendar month period following its effectivity on September 15, 1998, the time limit with respect to the period from arraignment to trial imposed by said provision shall be 180 days. For the second 12-month period, the time limit shall be 120 days. And for the third 12-month period, the limit shall be 80 days. So, dito naman sa Section 7, Public Attorney's duties where the accused is imprisoned. So, if the public attorney assigned to defend a person charged with a crime knows that the latter is preventively detained, either because he is charged with a bailable crime but has no means to post bail, or is charged with a non-bailable crime, or is serving a term of imprisonment in penal institution, it shall be his duty to do the following: promptly undertake to obtain the presence of the prisoner for trial, or cause a notice to be served on the person having custody of the prisoner requiring such person to so advise the prisoner his right to demand trial. Upon receipt of that notice, the custodian of the prisoner shall advise the prisoner of the charge and his right to demand trial. If any time thereafter the prisoner informs his custodian that he demands such trial, the latter shall cause the notice to that effect to send promptly to the public attorney. Upon receipt of such notice, the public attorney shall promptly seek to obtain the presence of the prisoner for trial. When the custodian of the prisoner receives from the public attorney a properly supported request for availability of the prisoner for purposes of trial, the prisoner shall be made available accordingly. So, what are the sanctions? In any case in which private counsel for the accused, public attorney, or the prosecutor knowingly knows that the case set for trial without disclosing that a necessary witness would be unavailable for trial, files a motion solely for delay, which he knows is totally frivolous and without merit, makes a statement for the purpose of obtaining continuance, which he knows to be false and which is material to the granting of the continuance, willfully placed to proceed to trial without justification, consistent with the provisions hereof, the court may punish the counsel, attorney, or prosecution as follows. So, sila ay pwedeng ma-imposed with a fine of 20,000 pesos. The counsel de officio naman, 5,000. By denying any defense counsel or prosecution the right to practice before the court trying the case for a period of 30 days. The punishment provided for by this section shall be without prejudice to any appropriate criminal action or other sanction authorized under these rules. So, Section 9, the remedy where the accused is not brought to trial within the limit. Now, so if the accused is not brought to trial within the limit required, the information may be dismissed on motion of the accused on the ground that the denial of his right to speedy trial. So the accused shall have the burden of proving the motion, but the prosecution shall have the burden of going forward with evidence to establish the exclusion of time under Section 3 of this rule. Failure of the accused to move for the dismissal prior to trial shall constitute a waiver to the right to dismiss under this section. Section 10, the law on speedy trial not a bar to provision on speedy trial in the Constitution. So, no provision of law on speedy trial and no rule implementing the same shall be interpreted as a bar to any charge of denial of the right to speedy trial guaranteed by Section 14, Paragraph 2, Article 3 of the Constitution. The order of trial. Okay, so for the order of trial, the trial shall proceed in the following order. The prosecution shall present evidence to prove the charge and in the proper case, the civil liability. The accused may present his evidence to prove his defense damages, if any, arising from the issuance of the provisional remedy. The prosecution and defense may, in that order, present rebuttal and sure rebuttal. And upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit a written memoranda. So when the accused admits the act or omission naman charged in the complaint but interposes lawful defense, the order of trial will be modified. So ito, kapag kunyari nag-plead guilty si accused But on account of a self-defense, yan, kunwari, yan, mababaliktad yung trial. So, mauuna na siyang mag-present ng evidence before si prosec. Yan. So, this is an example. Yan. Okay, Section 12, Application for Examination of Witness for Accused Before Trial. When the accused has been held to answer for an offense, he may, upon motion, with notice to the other parties, have witnesses conditionally examined in his behalf. The motion shall state the name, the residence of the witness, substance of his testimony, and that the witness is sick or infirm to afford reasonable ground for believing that he will not be able to attend trial or resides more than 100 kilometers from the place of trial or no means to attend the same or other similar circumstances. And the motion shall be supported by an affidavit of the accused and such other evidence as the court may require. Examination of defense witness. So how is it made? The court is satisfied that the examination of the witness for the accused is necessary. An order will be made directing the witness to be examined at a specified date, time, place, and that a copy of the order be served on the prosecutor at least 3 days before the scheduled examination. The examination shall be taken before a judge, or if not practicable, a member of a bar in good standing so designated by the judge in the order, or if the order be made by a court of superior jurisdiction before an inferior court to be designated therein. The examination shall proceed notwithstanding the absence of the prosecutor, provided he was duly notified of the hearing. A written record of the testimony shall be taken. Section 14 is bail to secure appearance of material witness. So when the court is satisfied upon proof or oath that a material witness will not testify when required, it may upon motion of the either party order the witness to post bail in such sum as may be deemed proper. Upon refusal to post bail, the court shall commit him to prison unless he complies or is legally discharged after his testimony has been taken. So, not only the accused may file bail. So, pwede rin ang witness. Yan, Section 14 yan. If if he is a material witness and the court is satisfied that he will not testify when he is required to do so. So, he may be required to post bail. Examination of witness for the prosecution. When it is satisfactorily appears that a witness for the prosecution is too sick or infirm to appear at the trial as directed by the order of the court, or has to leave the Philippines with no definite date of returning, he may forthwith be conditionally examined before the court where the case is pending. Such examination in the presence of the accused or in his absence, after reasonable notice to attend the examination has been served on him.